Massachusetts. Court is now open. You may be seated.
Good morning, Mr. Friley. Good morning, Leslie. You may proceed.
Good morning, Your Honors. May it please the Court. My name is Donald Frylew, and I'm here for Joseph A. Brear, Jr., as he is trustee of the Buttonwood Nominee Trust. Your Honors, as a quick preliminary matter, there's a little bit of confusion as to the issues that are actually going to be before the Court this morning. There was another issue raised in the appellee's brief that was in the nature of a cross appeal, and in the appeals court I had moved to strike it because there was no notice of the cross appeal.
We noticed that, yeah.
Yes, and I have a brief on this issue. I'm prepared to present oral argument on it this morning if necessary, and I would like the opportunity to submit a brief on it.
This is the extension of the 30-year? Is that what you're talking about?
Yes, whether it's something, a deed restriction of exactly 30 years duration is extendable under Section 27.
Well, you claim that this argument by the defendant should be stricken.
Yes, I do, Your Honor.
And you're still making that claim?
Yes, I am. But if it's not going to be stricken, I'd like an opportunity to brief it.
Well, did you file a reply brief?
No, I didn't. I filed a motion for 2 weeks after the decision, the ruling on the motion to strike. If it went against me, I was prepared to file a reply brief.
Well, I would suggest that you file a reply brief. Typically what happens, if there's a pending motion, it gets considered at the time, and you can't wait to get a ruling on that. We can't delay it in that respect because it's hard for us to make a determination before we've looked at the entire record. So I would suggest that you promptly file a reply brief with a motion to file it late, because I don't know whether or not the court will either rule on the motion or decide whether to accept it. But you can't wait until there's a ruling and then file something 2 weeks after that. Okay?
Okay, that was my understanding was that I was going to be able to do that.
That's
but
fine.
I guess I was a little bit confused.
If we rule in your favor on that issue, that would end the case.
Yes, but you don't want. The question is whether
Isn't
or
that
not you
right?
file something. We need to.
Well, if the 30-year extension isn't extended,
Yes.
then that's the end of the case.
That's the end of the case
That's
for
what
my
I'm
client.
saying.
Yes.
Yeah. So I mean,
Correct.
if we rule that there's no extension, that it shouldn't have been extended, that's it. We don't get to the other question.
That's
Yeah. Okay.
In any event, Your Honors, the issue before the court this morning is whether Chapter 184, Section 27A was intended by the legislature to supersede the established common law rules of construction such that where the instrument imposing a deed restriction does not literally say with absolute precision that parcel X or party Y has the benefit of or is entitled to enforce the restriction is not enforceable. Under common law, the rules of construction were that the identity of land benefited by a deed restriction could be inferred by the surrounding circumstances. And
but now we got a statute,
yes, Your Honor.
and the statute seems pretty clear, doesn't it?
Well, Your Honor, I don't believe it's quite that clear. And there is a literal reading of the statute that can be made, and
I thought that's the word.
it depends. Well, it depends on how you define a statement. Does a statement necessarily have to be literal, or can it be implied?
Well, it goes stated therein, and therein refers to the instrument imposing the restriction. So it has to be stated in the instrument imposing the restriction.
Well, I would say that there's an implied statement in the instrument imposing the restriction in this case because the instrument references a plan which clearly shows the adjoining parcel from which this conveyance was made. It was severed, and the grantors retained the homestead. And so, again, I mean, it's really pretty easy to see. It's obvious. Since there's no other stated beneficiary, it's got to be for the benefit of someone.
What do we do about, I mean, it seems to me another portion of 27A, which limits that limits who can enforce restrictions. And it says that as to even someone who is a, quote, party to the instrument, it must be, that the restriction must be stated to be for his benefit. It's apparently the statute isn't even willing to infer that that a party to the imposition of the restriction would necessarily be implied or inferred. But even in that rather extreme or obvious case, the instrument would have to state that it's for his benefit.
Yes, Your
I
Honor.
mean, we may think this is a bit extreme, but that's what the legislature seems to have said.
That's what the legislature appears to have said, but the statute shouldn't be interpreted so literally if it's going to go beyond the mischief that was intended to remedy. The appeals court in the Atwood v. Walter case concluded that the purpose of this provision was basically to keep the riffraff out, third parties who want to interject themselves into disputes over deed restrictions and try to claim enforcement rights. Now, what happens here with this hyper-literal reading is that the obvious intended beneficiary, the only intended beneficiary of this deed restriction, is kicked out. It voids the entire contract. I mean, this was a valid, contractually bargained for arrangement, and it's been voided by this interpretation of the statute. So it's gone way beyond the mischief intended to be remedied, and it's destroyed an existing vested right. And I just don't believe the legislature intended to do that. And and at common law, that this would be a perfectly enforceable deed restriction by the owner of the adjoining parcel, which was the retained homestead. Peck versus Conway makes it very clear.
Right. But it seems to me, one of the whole purposes of 27A was to provide, absolute clarity. Even in situations where, under the common law, we would have been very comfortable that we were making the right decision, the statute seems to impose that, say that even a party to it, it's got to be stated expressly. That seems to be the purpose, is indeed to change the common law and remove any ambiguity about this subject.
Well, I agree, but I just don't think there's any ambiguity here. We have an instrument imposing the restrictions, and we have a reference to a recorded plan that shows the retained homestead.
Well, I take it I think what's confusing, Mr. Filey, is your reference to common law. I take it that you would say, or you could say, I'm only looking at 184.27a, and the reference to stated doesn't mean in English, in words, you can look at the plan and take the plan as a statement, correct?
That's correct, Your Honor.
Right? So your reference to common law is not helpful. You have to do it within at least to me, you have to do it within the statute, and essentially it's dancing around stated. So if you look at the plan, and the plan is imposing some kind of restriction, and you look to the plan and you say, where was the restriction? It doesn't have to say the piece on the plan which is currently owned by X. Otherwise, this restriction doesn't have any meaning at all.
That's correct, Your Honor. I mean, as the Atwood court said, you can only be so literal in interpreting a statute, and that's why the Atwood court held that.
In other words, if you had a deeded restriction that nowhere indicated to what it was that the restriction applied, there's no statement in the contract itself, in the agreement itself.
But it's not a question of where the restriction applies. It's a question of who can enforce it.
Right?
That's correct. But again,
and I assume the plan is silent on the subject of for whose benefit the restrictions, which were actually in the deed, not the plan.
yeah, but the plan, yes, Your Honor, that's absolutely correct. But the plan does show the retained homestead of the Burge trustees who originally created the restrictions. So it was, it's adjoining land, evident from the plan, and
Could I clarify one thing? I take it that the original, the retained parcel, Burge parcel, adjoined, what is it denominated, parcel 1, which was also retained by Burge at the time. Is that correct?
yes, Your Honor.
Okay. But you did not buy, your client did not buy parcel 1. bought only the
Or only what the judge in the sketch has identified as the
As a
homestead.
result, what I'm getting to is, I take it, what your client presently owns is not contiguous to the lot that the Fagans want to develop. Is that correct?
That's correct, but the lot the Fagans want to develop was part of the whole
Right, I understand
subdivision
that.
that was conveyed away.
Right, but
in
you're
the
not
obvious
claiming,
intent.
you're not claiming, I just want to make sure, it appears you weren't in brief, but I want to make sure. You are not claiming that your land adjoins the subject parcel?
No, Your Honor.
Okay.
And can I just make sure that
This
I
is very difficult parsing of that.
Yes.
If
piece
you
of it.
look at
Okay.
if you look at the sketch which is attached to the land court judge's memorandum and decision,
Yes.
you are homestead parcel, correct?
Yes,
And parcel 1 is the one to which Justice Sussman has just referred, which your clients do not own, correct?
that's right. Yeah,
And
there's
the
a-
development is in parcel 2, parcel 3, parcel 4, correct?
That's correct.
Okay.
But it was conveyed that way in, those 4 parcels were, part of the subdivision, and they were all conveyed subject to the restriction.
And so for purposes of 184, Section 27A, you say that for those purposes, your client is, an owner of an interest in benefited land which adjoins the subject parcel at the time of enforcement. No, not there, right? Or you say you are?
Well, it's adjoining in that all these parcels were once part of this whole, and they were conveyed.
Right, but you don't adjoin it at the time enforcement is sought, which is what that first prong requires.
Yes.
Right.
I understand.
So you can only do it under, is stated therein to be benefited, correct?
Yes.
Okay.
And you're arguing that the grantors would not have imposed that restriction unless they intended themselves to be benefited.
Yes, Your Honor. Otherwise, it's a nullity. It's basically the decision of the land court was essentially avoiding of this restriction, holding it to have been void ab initio, because it didn't state literally that it was for the benefit of the retained homestead.
Right, but even there's this other part of 27A that even as to the Burridge Trust does say that even a party to the instrument, which the Burridge Trust certainly was, it would still have to be, quote, stated to be for his benefit.
I understand that, Your
I mean,
Honor. And
after all,
think
some
that's-
people impose restrictions and then leave, and it isn't really for their benefit. It's for somebody else.
But here, there's been continuity.
I
It's
know.
obvious. Who else could it possibly have been for?
but it
It's
should have
obvious
been
the intent was to benefit
Yes.
the retained homestead. And the question is, does this achieve the legislative purpose by voiding such a restriction, simply because it's basically poor drafting at the worst? I mean, the intent is obvious on the face of it. And if you have to go to the point of voiding a perfectly, otherwise perfectly valid contractual arrangement, it ought to at least serve the purposes of the statute. And this does not serve the purposes of Section 27A. It's not keeping third parties or, peripheral people out of the process. What it's doing is it's keeping the intended beneficiary out of the process. The purpose of the statute is to keep unintended people who are not intended to have the benefit of the restriction from seeking enforcement, not to void something that's, clearly obvious on its face. And that goes beyond the mischief intended to be remedied by the statute and doesn't serve the statutory purpose.
Although, Mr. Flylee, I try to suggest that you not refer to the common law, that the choice of the word stated within the legislative history, is there any reason to think that the legislature intended by the word stated to mean anything other than a clear statement that said this restriction, is for the benefit of, and then?
Well, the Atwood Court, again, held that it doesn't have to be so interpreted so literally that it has to say for the benefit of.
Right.
We could read the statute that literally and conclude that it must be for the benefit of. And also, I'd like to point out that there's The language, the punctuation in 27A, and there's no, get to my footnote on that, yes. It seems to suggest that if it adjoins a subject parcel at the time enforcement is sought, it doesn't have to be stated there and to be benefited. And again, I'm sort of taking issue with the idea that it doesn't really adjoin just because there's another parcel in between that happens to have been part of the subdivision and severed from the homestead. I mean, I would suggest that in a broader sense, all of those parcels are adjoining the homestead.
I just
And
have one
that's-
other question. The
You know,
defendant,
they could have been.
the defendant says that there's no restriction on the number of the houses that could be built, just that all houses have to be single-family ones.
Yes, Your Honor. That's
And what do you say about that?
I'm not sure that's an issue that's.
That's the subject of your reply brief.
Well, that's in your reply
Yes.
brief, yeah.
Yeah, that will be.
Yes.
All right, okay, all right.
Thank you, Mr. Flatley.
Thank you.
Mr. McCallan? Let's see.
Thank you, Your Honor. May it please the Court, my name is Michael McCarron. I represent the appellees, Edward Fagan and his wife. And I'd first like to address this question of it being obvious that what I would refer to as the homestead parcel, which is the parcel owned by the appellant, is clear that this is to be benefited from it. Because if you look at the plan that is the subject matter of the deeds, it only shows parcels 1, 2, 3, and 4. It doesn't show the homestead parcel at all. All that's shown on that plan is that it's abuts. There are no meets and bounds on the plan in which the deed, which imposing the restrictions, refers to. So when my brother suggests that it is obvious to apply to the homestead parcel, I would respectfully disagree. Because it could very well be the case that these restrictions were to apply to parcels 1, 2, 3, and 4, and for the benefit of those 4 parcels. But we don't know that because there's nothing in the deed to suggest to which parcel it is required.
Mr. McCallan, let me ask you this. In what respect would the restrictions benefit a subsequent owner of parcel 1 or parcel 2 or parcel 3 or parcel 4? What's the benefit?
The benefit of that would be that on those adjoining pieces of land, that they would be restricted to a single-family use.
And I take it that under the present zoning, you could have, under the time that the restriction was placed on it, there was availability to other forms of building?
You could have put multifamily. In fact, the record at the lower court will show that parcel 1 is now occupied as a multifamily dwelling. So at that time, you could put multifamilies in there. But parcel 1, at some point in time, actually owned by them, put in a multifamily, and it was never objected to.
So if had somebody chosen to I take it that at the time that the multifamily use was put in onto parcel 1, that the owners of the homestead parcel owned 2, 3, and 4.
No, I believe that took place subsequent. The owners of the homestead, I'm not sure exactly what the sequence of the different
But for whatever
parcels.
reason, the then owners of parcel 2, 3, and 4 did not object to the construction of a multifamily unit.
That's correct. That's correct. Well, I think it was actually more like a conversion of an existing building into multifamilies as opposed to a construction. But I don't know if that makes a difference.
It may. I mean, it may explain why somebody who is, you say, the beneficiary.
Right. But the point, Your Honor, is that we have a potential confusion here. While my brother suggests that it's obvious to benefit his client, I would suggest it is not so obvious. And in fact, That is one of the purpose of the statute. The statute is elementally clear. It says that there shall not be enforced, shall be unenforceable, unless you comply with these terms. And the terms is it as to a party. A party must be stated for his benefit. In this case, we have nothing. We have an absolute blank. And what, in fact, what my brother is asking this court to do is to simply erase that portion of the statute.
So your view is that this is a nullity anyway. No one can enforce this because no one's named as the beneficiary of it.
That is correct, Your
But I
Honor.
ask you, I mean, it seems to me one of the ways that it might not be a nullity, and I think even in the absence of punctuation, I think the grammar would go that someone who adjoins the subject parcel at the time enforcement is sought has standing to enforce. And that would be somewhat consistent with what you were deciding. In other words, parcel 2, the owner of parcel 2 could enforce it against the owner of parcel 3
And one.
because they were contiguous at the time enforcement is sought. Because the or goes is describing the instrument imposing restriction and is stated therein. Therein refers to the instrument. If you make it either adjoin subject parcel when enforcement is sought and is stated therein to be, there's nothing for the therein to refer to.
Although-
It would seem to me that the genuinely contiguous parcels still have the benefit of this restriction, and that's one way to avoid making it a nullity. And it's at least somewhat consistent with your theory that it was being imposed for the benefit of parcels 1, 2, the same people subject to the restriction were getting the benefit, at least as to their immediate neighbor or neighbors.
I would suggest that, I'm not suggesting that another parcel has a benefit. I'm suggesting that there are alternative interpretations of who gets the benefit and therefore goes to the why that needs to be stated. I would respectfully disagree with your reading because I read the clause as is the owner of the parcel of land benefited which adjoins or is described in the instrument, and then you go, and is stated therein to be benefited.
Yeah, but that leaves the therein refers to instrument. And there's nothing for it to refer to in the clause either adjoins the subject parcel at the time enforcement is sought.
But my interpretation would make it consistent with 1A, because basically is what it does is it puts a two-pronged requirement either on A1 or A2. It must be A,
But I must
party,
say, that would
and
make the whole reference to adjoins the subject parcel useless.
No, because it would be if you adjoin the subject property and are stated in the deed.
So you're reading it as if it were a benefit, it would benefit a person as opposed to running with the land.
Well, you could
No,
it says interest in benefited land.
Okay.
And what I'm saying is that under both A1 and A2, it's a two-pronged test in each case.
Well, I think, with all due respect, I think grammatically that's probably not correct. And I must say it would make more sense to me if what we're trying to do is eliminate peripherals and unintended people. Somebody who adjoins the subject parcel has such an obvious interest in the restrictions that go with that parcel that you don't need to say anymore. And I must say, I think it's helpful. I don't know why you're fighting this, because I think it's helpful to your argument, a way of saying, no, this is not, interpreting the statute this way does not render these restrictions a nullity, at least during the time period they were enforceable, whatever that is.
Right.
That, your client could, in fact, enforce this against parcel 1.
Could have, but didn't.
Didn't.
Elected not.
Exactly. Didn't, but could it?
Mr. McCallan, could I ask you just to address the Atwood case in this respect? I'm not suggesting that the Atwood case goes as far as Mr. Flylee suggests it does, but there it seemed to me that what the appeals court was doing was saying you don't actually have to use the word is for the benefit of, but you look to who the intended beneficiary, I mean, there was a written
Right, but, well, I think in that case, Your Honor, is what they used is basically synonyms for benefit, and that basically the ruling was that the English language was flexible enough that you could discern from the document the language in there, because in the Atwood case, it was clear in the document that the developer, who was a person who was to have the benefit,
Right.
had the rights, and they went into cite the developer's name and the rights that he had.
Correct.
And
So you, in other words, you don't have any problem with the Atwood decision?
I don't have any problem with the Atwood's decision.
Okay.
And because
Okay.
basically what it says is, Your Honor, is that you don't need a magic word.
No, okay,
to do it.
that's fine. I
Okay.
mean, when I read the Atwood decision, that was my understanding, that there's enough stated in the instrument itself that identifies the developer, Atwood, plus...
Right.
Okay.
But in this particular case, we have a circumstance where there is nothing stated, where there is absolutely nothing stated. And the statute was implied, and this is a deed that was drafted 11 years after the statute had been in place and in force, and, and applicable to this particular piece of property. And I disagree with my brother when he brings in the common law, because I believe that the statute was made to codify the provisions of common law, but also to add procedural requirements.
Well, one of the things that the legislature has plainly tried to do over in a variety of different contexts is to make it clear for people who are purchasing property or for people who are, dealing with property to know exactly what the restrictions are, who can benefit from them, what potential lawsuits they're going to...
And we don't have that in this
And
particular
essentially
case.
what we say is put it in the instrument and record the instrument. That's what you do, correct?
Exactly, Your Honor. And I would suggest that this Court, no word in a statute is superfluous, that all should be given its common and everyday meaning. And also, we should look at the nature and the policy against restrictive covenants in general. Restrictive covenants ought to be construed strictly against the person claiming them. That has been common law. That has been enunciated, again, in the policy of the statute. And the policy should be against a grantor in favor of free alienation. And that has been cited numerous times by the Court. And they are to be narrowly construed. So in a circumstance where, in this case, where the statute is, in my estimation, elementary clear as to what you must do, you must state it. If you don't do it, that's why the judge says, look it, the statute imposes this requirement. It says it's unenforceable unless this is done. I would suggest to you that it would be inappropriate to delve into the realm of spectral evidence to imply, it is Essex County.
That's right. You mean that's not the law still in Essex County?
Well, you may try to recreate the courts of Hoya and Termere, but again, what you do is you suggest to take a clear requirement that it be stated, that it be written, that it be physical, and make it amorphous and unclear. I would suggest that...
Well, let me put it this way. From my own point of view, I don't think there's any question that this was intended to benefit the homestead parcel.
Well,
it just wasn't stated.
Well, Your Honor,
I
disagree.
Who's conveying the parcels?
Is the trust. But I disagree in the fact that...
At the time the restriction was put on.
It would be the trust.
And who owned the homestead parcel?
It would be the trust.
You got it. And
Right.
when you start conveying out and you want to have some development up there, you're going to be very careful that you can control the development.
But again, Your Honor, I guess the purpose of the statute is...
I understand.
That we don't have to delve into those particular...
I understand. And maybe there's a malpractice action here for the statute of limitations.
A little beyond the statute.
Run.
Well, as the Chief Justice is suggesting, for what purpose would the restrictions be there if they weren't to benefit the grantor?
An alternative view, Your Honor, would be that it was for the benefit of the four parcels themselves.
Oh, come on.
Well, we don't know.
Then why would the grantor have put it in?
Excuse me?
Then why would the grantor have gone to the trouble of putting it in?
Because they were also the grantor of the other parcels, too.
I understand, but he doesn't even have buyers. He's got a big piece of property, and he's selling off some of it, or they're selling off some of it, because they, who knows, they probably want to pay the taxes that Essex is taxing them up the yin-yang for, and so they put it way at the northern part, but they want to make sure that they don't have overhead electrical wires and the smell of animals and all kinds of things, that they don't want to have impact their homestead parcel. That's why they did this.
Well, Your Honor, again, you can speculate
I'm
as
not
to that.
speculating.
But
I'm stipulating.
But there's nothing in the record to guarantee it. And again, that's why the statute imposed it, whereas so that it wouldn't be necessary to have multiple court case each time restrictions to make a determination as to who has the benefit. They said because the principle, the policy, is that we are against restrictions, we are not in favor of them, we're going to impose additional conditions upon them in order to make them enforceable. We are going to limit them with their applicability and their
No,
time.
I understand.
I mean,
I
the whole
understand.
purpose of that is done within the statute.
I mean,
So,
These are wonderful restrictions. You know, you've got to build a fancy house, and you can't. I mean, they're really great restrictions. The lawyer
5
had-
horses only.
The lawyer had a wonderful time figuring out.
and while the way I look at it, Your Honor, is that what the judge did is the judge never went to the issues of whether the 30 years have elapsed because the statute, I mean, because he said that the restrictions were void, were not forcible, so he never got to the question of whether 30 years. But I would also point out that this restrictions say in the face they're good for 30 years. Under what category can 30 years be extended any longer than what is written in the deed? I don't understand how it's under the Stop and Shop case, restrictions that are unlimited as to are limited to 30 years.
Wait a
It
minute,
can't
I
be
don't
extended.
understand, I'm sorry, why you say that the judge didn't reach the 30-year issue. When he says, consequently, I find that provided all applicable requirements are met, a notice of restriction may be filed for the purpose of extending the period of enforceability.
Because in
And then
this
he says
case, he
regardless-
ruled that there were no restrictions.
Right, so there are no
you
restrictions,
never
right.
got to that ruling.
It was dicta,
It was
dicta,
right, okay.
but it's there.
But it's
there,
there.
but it is dicta. It's not a rule.
But it's there.
Well, I think it's helpful to the land court judge in case we disagree with him on whether or not it's enforceable by the plaintiffs in this, by the, who's here, the plaintiff, yeah, Mr. Friley's client. You know, that in case we reached a contrary result, or do reach a contrary result, we then have to deal with the other piece of it. Correct?
Right. Thank you.
Thank you, Mr. McCowan.